collateral and priority of payments and leases and all that business. And I think the history shows that that's what Fifth Third Bank was trying to do. And, you know, one thing was common throughout this whole trial, that is everybody wanted to protect the subcontractors. You know, those subcontractors, they have small businesses. Our brothers and sisters, our aunts and uncles work for them. And we need to make sure that they're taken care of. Now, they jump up and down about the fact, well, this May draw, it was, you know, funded, delayed, and a lien was filed, and then, you know, some of these arguments just don't make any sense. If the lien was filed in May, and a draw request was submitted and funded in May, why didn't the lien go away? That's an exhibit. It's in the 100 somewhere, 103, 104. Look at the jobs that Hawk wasn't paying its subcontractors for. It wasn't only this job. There must be 10 of them in there. They weren't paying for anything. It's kind of reminiscent about this whole deal, I think. You know, there was a way, and the other thing I want to mention is, you're not going to get any jury instruction that says who breaches first. And explain this, even if you did, how can you explain this? Well, we poured these extra pads we weren't allowed to pour. The bank gave us money to pay for those, even though it didn't have to do that. Boy, the bank breached. Think about that logic for a second. A breach is when you do something that is to the detriment of the other side. It's not something that you do that benefits the other side. It's not a breach. That's the antithesis of a breach. It's just the opposite. There were so many things that City Center could have done to come into compliance, to stabilize this project, to protect everyone involved. Not only the subs, but itself, its bank, everybody. They could have got valid leases. They didn't do that all the way through November. They didn't inject equity into Building 6. There was just unaccounted for funds that somehow were injected into the building. Well, just let me talk about those pads for a second. You know, there's one thing that each of you have that you're going to use to decide this case. You've had it all along. That's your common sense. You're going to take that back into the jury room, and you're going to utilize that common sense. Now, common sense tells you that based upon the area of the country where we live, that foundations have to be underground. There's a frost line. Common sense tells you it's about 3 feet down. That's where the frost line is. You have to put footers below the frost line so that buildings don't heave in the wintertime when the frost occurs and the ground freezes. Those blocks are, remember how high they were? 4 blocks high. They were sitting on the footers below the ground, and those are the pads that were authorized by the mini blue anyhow. So I don't know what the big to-do is about that, and why we keep bringing it up. They admit, for the first time, they admit that they bought Flexicore for 2 additional buildings that were being stored off-site. If you bought their complete argument that buildings, the first 2 buildings built were operating this way and the next 2 were operating under another set of rules, they were in violation, and they admit they were in violation for those buildings by buying windows, awnings, Flexicore, and all these things for vertical construction on the other 2 buildings. That, at this point, is without any contention at all. Took my placards down. Anytime there's a provision in that contract that they don't want to adhere to, they figure out, well, they did this, they did that. You know, this construction loan agreement, even Mr. Plank said it was boilerplate. You know how clauses become boilerplate? They get inserted into documents over and over and over again, over years and years and years. And they get massaged, and they get changed a little bit. You know why they do that? You know why those clauses exist in the first instance? It's not because some brilliant lawyer sat down and drafted this thing from scratch. It doesn't work that way. This is years and years of experience. And you know why? Because people that owe banks money sometimes don't like to pay it back. And so you have to have a contract that defines very succinctly, very clearly the obligations of the parties so that there's no disagreement, so that there's no wiggle room, and so that everybody knows up front. You can sit down and look at it and say, these are my obligations. So it's as simple as this. Do you want to live up to your contract or don't you? That's as simple as that. If you decide that contracts aren't worth the paper they're written on, then there's nothing I can do to sit here and convince you otherwise. But if you're convinced that under the law, under the great law of this land, that a contract, documents like the Constitution mean something, that papers written that you sign your name to mean something, then there's only one conclusion. And that conclusion is they didn't comply, they defaulted, you gave them chance after chance after chance to do so. No, those aren't breaches, ladies and gentlemen. A breach is not giving someone a chance to come into compliance. A breach is they haven't even stated when the bank breached. Have they given you a date? And the last thing I want to say, and it's just because it just struck me, on the notice of default, if you look at the promissory note, it's Exhibit 5, Paragraph 9. They waived notice of default. The bank wasn't required to notify them of anything at any time regarding default, just to prohibit what they're doing now. It's all smoke and mirrors. They want to avoid the contract. They want to avoid their obligation. Don't let them do it. Please don't let them do it. The figure was $6,227,000 some odd dollars. That's the judgment that should be rendered in favor of Fifth Third Bank against City Center Complex, Mr. Richard Plank. Thank you.
Pass them up. Ladies and gentlemen, at this time it becomes my duty to instruct you as to the law that you will apply to the facts and issues in this case. You are the sole trier of the facts, but you are bound to apply the law as given to you by the court. When you deliberate your verdict, you will have a copy of the final instructions and all exhibits admitted into evidence for your review. Everyone have one?
Yep, you got them now.
Yep. All right. Court's final instruction number 1. As I said in my preliminary instructions, judges and jurors perform different tasks. I instructed you on the law at the start of this trial, and I will now further instruct you on the law. You will decide the facts of this case, then you will decide the outcome of this case by applying all of my instructions to those facts. Instruction number 2. Consider all of my preliminary instructions and final instructions together. Do not single out any individual sentence, point, or instruction and ignore the others. Number 3. Evidence is of the greater weight if it convinces you more strongly of its truthfulness. It is evidence that convinces you that something is more probably true than not true. A greater number of witnesses testifying to a fact on one side or a greater quantity of evidence introduced on one side does not necessarily amount to the greater weight of the evidence. Instruction number 4. The parties in this case may prove a fact by one of 2 types of evidence: direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact. Circumstantial evidence is indirect proof of a fact. For example, direct evidence that an animal ran in the snow might be testimony of someone who actually saw the animal run in the snow. On the other hand, circumstantial evidence that an animal ran in the snow might be the testimony of someone who only saw the animal's tracks in the snow. It is not necessary that any fact be proved by direct evidence. You may consider both direct evidence and circumstantial evidence as proof. Instruction number 5. You alone are the judges of the evidence, including the credibility of witnesses. Credibility means believability. A credible witness is a witness whose testimony you believe. In considering the testimony of a witness, you may take into account his or her ability and opportunity to observe what he or she has testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all of the evidence you have heard. Assume that each witness has testified truthfully. If you find conflicts in the evidence, reconcile those conflicts, if you can, based on the assumption that each witness has testified truthfully. Do not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. In determining what or whom you believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. Court instruction number 6. Parties may attack the credibility of a witness by showing that the witness made a statement or behaved in a manner inconsistent with the witness's testimony. You may consider the fact that the witness spoke or acted inconsistently with his testimony in this case, or determine the weight you will give to the testimony given during this trial. However, if a witness testified inconsistently under oath, either in this case or in any other case or court proceedings, you may also consider the content of the witness's prior inconsistent statement as evidence in this case. Generally, a witness may not express an opinion. However, this is instruction number 7. Let me start again. Generally, a witness may not express an opinion. However, a witness may be permitted to express an opinion because of his or her knowledge, skill, experience, training, or education. Judge opinion testimony in the same manner that you judge other testimony. In deciding how much weight to give opinion testimony, you may also take into consideration 1. The witness's skill, experience, knowledge, and familiarity with the facts of the case. 2. The reliability of the information supporting the witness's opinions. And 3. The reasons for the opinion. Court instruction number 8. A party may present testimony by way of written or videotaped deposition or transcript testimony. A deposition is a sworn testimony of a witness taken before trial. The witness is placed under oath and swears to tell the truth, and the lawyer for each party may ask questions. The court reporter is present and records the questions and answers. A transcript is a sworn testimony of a witness from a prior trial or legal proceeding. Evaluate this testimony using the same rules you apply to the testimony of other witnesses. Court instruction number 9. You must not consider testimony or exhibits that were admitted into evidence. Number 10. A breach of contract occurs. 1. When a party fails to perform all of the duties it agreed to do, or 2. A party places itself in such a position that it is beyond its power to perform the contract. Instruction number 11. If you decide Fifth Third has breached the contract, the measure of damages is the amount that would put City Center in the same position it would have been if the contract had been fulfilled. Court's instruction number 12. To recover damages from City Center, Fifth Third must prove all of the following by a greater weight of the evidence. 1. Fifth Third and City Center entered into a contract. 2. Fifth Third performed its part of the contract. 3. City Center failed to perform its part of the contract. 4. City Center's breach of contract damaged Fifth Third. 5. The parties reasonably anticipated those damages when they entered into the contract. And 6. City Center's breach of contract was a reasonable cause of those damages. To recover damages from Fifth Third, City Center must prove all of the following by the greater weight of evidence. 1. The parties entered into a contract. 2. City Center performed its part of the contract. 3. Fifth Third failed to perform its part of the contract or performed its share in a defective or insufficient manner. Fifth Third breach of contract damaged City Center. 5. The parties reasonably anticipated those damages when they entered into the contract. And 6. Fifth Third's breach of contract was a reasonable cause of those damages. A person's conduct is legally responsible for causing an injury if 1. The injury would not have occurred without the conduct, and 2. The injury was a natural and probable and foreseeable result of the conduct. This is called responsible cause. Court's instruction number 13. If you decide that City Center has breached the loan agreement, the measure of Fifth Third's damages is the amount that would have been due to Fifth Third under the loan agreement that has not yet been paid, together with interest as provided for in the loan agreement. Fifth Third may only recover the loss actually suffered and should not be placed in a better position than if the defendant had not breached the contract. 14. If you find that Plank breached his guarantee agreement with Fifth Third by failing to pay City Center's debts, the measure of Fifth Third's damages against Plank is the amount that you find that City Center owes Fifth Third under the construction loan. Court's instruction number 15. A course of dealing is a sequence of previous conduct between the parties to a particular transaction which is fairly regarded as established a common basis of understanding for interpreting their expressions and other conduct. A course of performance or dealing exists if A. agreement of the parties involves repeated actions for performance by a party, and B. the other party, with knowledge of the nature of the performance and the opportunity for objection to it, accepts the performance or acquiesces in it without objection. Course of performance or dealing is relevant to show a waiver of any term inconsistent with the course of performance. Number 16. A contract is an agreement that arises from an offer made by one party and acceptance of that offer by another. A unilateral contract begins when one person promises to do something if another person acts or refuses from acting in a certain way. The contract is formed when the second person acts or refrains from acting. and the first person must fulfill his promise. Number 17, City Center proves all of the following by a greater weight of the evidence. The bank made a definite and substantial promise expecting City Center to rely on it. City Center reasonably relied on the bank's promise. 3, City Center was harmed as a result. 4, fairness requires that the promise be enforced. Then the bank is bound by that promise. Number 18, an entity that acts in good faith under a contract and substantially performs what the contract requires may recover damages from the other party to the contract. It may recover the agreed contract price minus the lost value caused by minor defects in that work. 19. You decide that performance at the exact time agreed upon was vitally important to the parties. You may decide that failure of a party to perform on time is a breach of contract. In a contract that fixes no specific time, the law implies a reasonable time for performance. Number 20. To recover damages for fraud, City Center must prove by the greater weight of evidence that 1. Fifth Third made false statements of important past or existing facts. 2. Fifth Third knew the statements were false or made them recklessly without knowing whether they were true or false. Fifth Third made the statements to cause City Center to act upon them. 4. City Center justifiably or reasonably relied and acted upon the statements. And 5. City Center was damaged as a result. 21. Fraud cannot be based on unfulfilled promises or on statements concerning future events. 22. A party claiming fraud must use reasonable care in guarding against fraud. Reasonable care means being careful and using good judgment and common sense. 23. To recover damages for wrongful interference with a business relationship, City Center must prove by the greater weight of evidence that 1. A business relationship existed between City Center and Hawk. 2. The bank knew the business relationship existed. 3. The bank intentionally interfered with the relationship. 4. No justification existed for the bank's conduct. 5. The bank acted illegally in achieving the bank's end. And 6. City Center was damaged as a result. Number 24. A person can waive his or her known right by voluntarily and intentionally giving it up. If City Center proves by a greater weight of the evidence that when the bank acted, it 1. Knew it had the right to tell City Center if bank was not satisfied with the information it was receiving from City Center or with the action City Center was taking, so as to put City Center on notice that more information or action was required in order to satisfy bank. 2. Fully understood that right, and 3. Intentionally gave up that right. Then you should decide that bank waived the right. 25. To return a verdict, all of you must agree to it. In other words, you must be unanimous. Each of you must decide the case for yourself, but only after considering and discussing the evidence with each other. You should try to agree on a verdict if you can do so without compromising your individual judgment. Do not hesitate to re-examine your own views and change your mind if you believe you are wrong. But do not give up your honest belief just because the other jurors may disagree or just to end the deliberation. Juror number 26. When you return to the jury room, select one of your members as presiding juror to manage the deliberation. No one will be allowed to hear your discussions, and no recording will be made of what you say. The bailiff is available to assist you with personal needs, but cannot answer any questions about the case. If you have any questions for me, you must put them in writing and give them to the bailiff, and I will respond as the law permits. You may be able to find answers to your questions by reviewing my written instructions and all the evidence. If at any time you are not all together, or if you are outside the jury room, you must not talk about the case among yourselves or with anyone else. I am giving you forms of possible verdicts. The presiding juror must sign and date the verdict to which you all agree. Do not sign any verdict form which there is not unanimous agreement. When you have agreed upon a verdict, inform the bailiff. When the parties are present, the bailiff will bring you back to court. Bring all the verdict forms signed and unsigned with you at that time. I will read the verdict aloud. Each of you may be asked if it is your verdict. Otherwise, you are under no obligation to discuss your verdict or deliberations with anyone. Your court's file instruction number 27. Jurors numbers 115 and 195. You have been selected as alternate jurors. Your duties are the same as those of regular jurors, except you must not participate in the deliberations or voting of the jury, unless I direct you to do so. The presiding of the jury shall prevent alternate jurors from deliberating or voting with the jury. The presiding juror shall promptly report any violation of this instruction to me. All right, ladies and gentlemen, in a few moments you're going to retire to deliberate your verdict. After you do retire to the jury room, your first act is to choose among you a foreperson, a presiding juror. The court is prepared, and you'll have your verdict form. I know it's late, and I know sometimes jurors want to get into the mode of deliberation. If you wish, I'll allow you to go home this evening and start tomorrow morning at 9 with your deliberations, or you can stay and deliberate this evening. And if at any time you don't think you can come in with a verdict, I could excuse you. So I'll let you decide that. If you wish to go home now and come back.
Stay.
Stay, all right. Okay, so when you reach your verdict, you just enter them on the forms as provided. There's the guidelines in the jury room to show you, to explain to you, to choose your jury, choose your presiding juror, and how you're going to deliberate. And some guidelines you could use. You don't have to use them, but they're there for you if you wish. All right, will the bailiffs come over? Commissioner Novak and Paul Georgie, will you please raise your right hands? Do you solemnly swear that you will take the jury to a convenient place for deliberation, that you will not communicate with them yourself with regard to this case, or allow others to do so? Ask them if they have agreed upon a verdict, and they having do so, you will then return them into the open court. So help you God?
Yes, sir.
Ladies and gentlemen, you may retire to deliberate. All rise.
You can't take the red one because not everything is.
Your Honor, they have 8
Everything.